My name is Salaar Khan. I'm an advocate of the high courts and I also practice in the lower courts. Presently, I'm assisting Noor Mukadam's family on the case as part of the legal team. I thought it was important to do this video, not to discuss the precise facts of the case, but just to kind of contextualize them, because one issue that seems to be quite prevalent at this point in time is that in a case that generates such public interest, emotions are very high. And people expect a certain swiftness of process that the law deliberately avoids. So in order to contextualize that, I thought it was important to provide some of the relevant law and just give a general sense of how long this might take, what some of the factors might be, without getting into any of the details that might prejudice the case itself. So in this case, the primary accused person has been charged under section 302, which is the punishment for qatl amd, which is intentional murder. What that requires is two things. Number one, that you not only committed an act that resulted in death, but at the time of commission, you had that kind of intent which would either lead to grievous bodily harm or death. So with regards to the punishment, when we're speaking of murder, in a case like this, we are specifically referring to qatl amd under section 302. And that comes in two categories. Number one, if it's under qisas, then that is punishment with death. If it's under ta'zir, it can be either death or it can be imprisonment for life. And then as you go down the list, you have different kinds of murder that then carry different forms of punishment. But the relevant one in this case, because it's mentioned in the FIR, is 302. In a case like this, of a criminal nature, what you have to do is prove your case beyond reasonable doubt. That's the legal standard. So that's a pretty high threshold. And the threshold in criminal cases is much higher than civil cases. Now, in order to do that, you have to present relevant evidence, which again is structured by the Qanun-e-Shahadat. But the relevant evidence that you have to produce is all procured from the scene of the crime or connected areas. Now, there's several points of exposure where it's very important that the evidence is properly handled. So let's say a crime has been committed. Now, how long does the police take to arrive at the scene? What does the police arrive at the scene with? What does the police do after they've arrived at the crime scene? How do they handle the evidence that they're collecting? How do they transport it? And then how is that evidence processed? Now, these are all points of exposure where we need to be very careful, because these blood samples, for example, or DNA evidence, if it's contaminated, then an open and shut case, so to speak, you will not be able to possibly prove it beyond reasonable doubt then. And this is actually something that is quite unfortunate, quite concerning in the Pakistani context, is that there's quite a paucity of resources when it comes to things like this. In the case of Islamabad, the ICT, until a very recent report found that it might have been adjusted since, but very recently, the numbers showed that the average cost in terms of resources allocated to a murder case is 19,600 rupees. Whereas the projected cost or the projected amount required for a case of that nature is at least 5 times as much. So if you have 20,000 rupees, say, that you're allocating to one case, and a DNA test costs something like 15,000 rupees. So we have to be aware of the fact that a lot of the time, even if the police wants to do something, they might not have the resources for it. So in practice, hypothetically, what something like this often results in is the police might arrive at the crime scene in a completely timely fashion. However, they might not have the appropriate instruments to secure the evidence. Something as simple as the kind of bag that would secure evidence and prevent contamination, they just might not have that. And that's often happened in the past. Now, with something like that, this is one point of exposure at which vital evidence for the case might be contaminated. Moving beyond that, another thing that Pakistan really struggles with is basic crime scene management. So one fundamental principle, for example, is that a crime scene ought to be cordoned off. And once you arrive there, then you have to be very sensitive of what to touch, what not to touch, how to handle certain things. These are still things that are better in major cities, but the more rural areas, these aren't really things that are factored in as such. And then you kind of lead to the point where you have to actually process that evidence. So Punjab has one of the relatively better forensic institutes. And often other provinces want to send their samples to Punjab as well. But all of this cumulatively is the state is doing all of these things, and the police is involved in all of this. But there's so many different people involved, component parts of that, and there's so many gaps between each person that unfortunately in so many cases where you might have a very open and shut case, because of small things like this that might not be entirely even the police's fault, you face a lot of challenges in the eventual outcome. So the Code of Criminal Procedure has a schedule at the end. It has this entire table that goes through all of the offenses, and it tells you which court they will be triable by. So for more egregious offenses, you approach the Sessions Court. Even for violent crimes, some will require the Sessions Court, others might be the Magistrates Court. Once a trial is conducted and you have a decision, that can then be appealed all the way up through to the Supreme Court. Even individual orders, such as an order for bail, can be appealed all the way up. So the idea that there's just, in a case like this, that there's just going to be one trial that will just determine the end of things, that's not true. You can have one outcome determined by by a court, and you might, the sentence might be commuted later on by a higher forum. The decision might be reversed altogether because of a finding that you weren't able to prove your case beyond reasonable doubt. So for all of these things, there's all of these different combinations, permutations that could happen, where each thing can be argued at multiple levels and often does. Now the anti-terrorism court, where this comes in, is another, it's one of those things where heightened emotions tend to play into expectation. The Supreme Court, again, has been quite clear in its articulation of the use of the Anti-Terrorism Act, as well as offenses that are triable by anti-terrorism courts. What the Supreme Court has held is that the Anti-Terrorism Act itself defines what terrorism is, and they have scheduled offenses. So Parliament can, over time, add further offenses to it. But generally, you'll recall that a criminal act such as this is composed of two things. You have the guilty act, and you have the act and the state of mind, or the intent that led to it. And the state of mind, the intent, is what distinguishes offenses of terrorism. So a layperson might say, for example, that this is such a heinous offense that, it evoked terror within us, or within society, particularly in a case like this. But it's not enough for it to have that outcome. There must have been that intention of creating that kind of terror within society, or of overawing the government, or of promoting a certain sectarian or motive of that kind. So these are all cases that are triable by the anti-terrorism courts. It's not to take away from the heinousness of the offense in any way to say that it doesn't fall under the ATA, just that the ATA, the Anti-Terrorism Act, was created for a very different purpose. With bail, the fundamental principle is twofold. Number one is the presumption of innocence until you are proven to be guilty. And the second is your constitutional rights to liberty and security from arbitrary arrest and detention. With bail, the first important point is that offenses fall into two categories. There's a very long list of offenses, so I can't list all of them. But generally, bailable and non-bailable offenses are separated by law. Now, there's a misconception often that a non-bailable offense means that you cannot get bail. That's not the case. The distinction between the two of them is that a bailable offense, in that case, you get bail as a matter of right, whereas in a non-bailable offense, you get bail at the discretion of the court. Now, bail further comes in two kinds of situations, broadly speaking. You can have pre-arrest bail and you can have post-arrest bail. Pre-arrest bail, also known as anticipatory bail, it's allowed in an even smaller range of circumstances than post-arrest bail. The standard is higher because what you have to prove over there is that you suspect that the proceedings against you might be on the basis of what is called mala fide, or malice in intent, and that there's no grounds for your arrest or your connection to all of this, and perhaps on the basis of an enmity, you might be arrested by the police. And these are all things that the Supreme Court in Suhram Bibi and Khizr Hayat before it was kind of grappling with. You know, this idea that just by nomination in an FIR you should be arrested. And it recognizes that arrest comes with certain costs to a person's dignity, reputation, etc. So sometimes you might seek pre-arrest bail. In other cases, you might seek post-arrest bail. Now, in non-bailable offenses, there's certain thresholds that you have to meet. The relevant provision is Section 497 of the Code of Criminal Procedure. This kind of creates this distinction, broad distinction between offenses. If it is the case that the offense that you committed comes with this term of 10 years or more, then the presumption is that you will not get bail unless certain conditions are met. And those fall under 497 subsection 2. 497 subsection 2 broadly covers what is known as further inquiry. What further inquiry means, it actually focuses on the wrong part of the provision, but the idea is that there are reasons to demonstrate that your connection to the case might not be as tangible, and it might be a case that requires further inquiry. And in the meantime, you should be released on bail. The principle of bail is you want to secure the person's attendance at the hearings subsequently. So for that purpose, you take what is known as a surety. And it has two components. It's a financial component, and it's also linked to an individual to ensure that this person will then appear before the court and will continue with all of these things. One final layer of caveats is that there might be situations in which you might be considered a danger to society, or that you might, for example, tamper evidence and so on. These are situations in which bail might not be granted to you. Since we're having a general discussion about the kind of context for criminal law within which a case like this emerges, it is important just to mention at the outset that though there's been a lot of discussion of insanity or potential insanity of the accused person in this particular case, no such defense has actually been taken by their counsel. This is just a factual assertion as of now. The defense of insanity has not actually been taken at any point during the court proceedings. One thing that this does is the later, at any point in time that a defense like this is taken, the less potent it's considered to be, because the idea is that it came as an afterthought. So all of this talk is mostly just stuff that's happening outside of court, whether it's coming from laypersons or from the accused or people linked to the accused. None of it is actually relevant to the case at hand because the accused himself has not taken that defense. Moving on from there though, because this is something that's been discussed and there's a lot of talk about this, the definition of what is commonly known as insanity and legal insanity or unsoundness of mind, they're two separate things. So unsoundness of mind is a general exception that falls under Section 84. And what that speaks of is a very particular kind of, because a very particular kind of situation. To return to the two elements of a crime, there's the guilty act and the guilty mind. So what insanity does is it affects the guilty state of mind. To the extent that if you are considered of unsound mind under the law, then what that means is that at the time of the commission of the offense, you were not aware that what you were doing was a crime. So generally, crimes like this are treated as crimes against the state. What that means is that although you might have a private individual at the other end, a victim of that case, the state is also party to it. Consequently, there are state prosecutors who are envisioned as the people who will actually prosecute the person for their crime. Now, in Pakistan, historically, this has been an area where we've been lacking. A lot of prosecution departments have not been created when they should have been. And even those that are might have very capable, well-intentioned individuals, but just the sheer lack of resources again results in their being overburdened with many cases for which they're underpaid and so on. As a result of this, what happens is that often what private parties want to do in order to get the best possible justice they can, they kind of insulate themselves or they kind of add a further cushion of private counsel as well to that. Which is why so often parties in situations like this have their own independent legal counsel or legal team. Now, in a case like this, in this particular case, the lawyers, as of now, are all offering their services pro bono. But this is, again, likely to be a very long process. So there's no way of knowing at what point we get to the High Court. That High Court decision might be appealed before the Supreme Court. Each individual order might be appealed. So all of these things together, there's so much litigation that requires so much effort, legal effort, that it's indicative of the fact that so many people are just excluded from this entire system just because the costs are so prohibitive.